To the Supreme Court, the justices issued a major decision over voting rights today, siding with a lower North Carolina court for striking down a congressional districting plan for violating state law. The case, Moore v. Harper, was brought after an updated census in 2020 gave North Carolina an additional seat in the U.S. House. This also allowed the Republican-controlled legislature a chance to redraw its election map. Multiple lawsuits found the map was gerrymandered to benefit the Republican Party. The decision by the High Court gives state courts the power to check state legislatures when dealing with federal elections within limits. And with that, let's bring in Hans von Spakovsky, Senior Fellow in the Meese Center for Legal and Judicial Studies at the Heritage Foundation. Hans, good to have you with us.
Sure, thanks for having me.
Great to have you. So the ruling does suggest limits to a state court's ability to police elections and Congress and the president. What do you make of this ruling?
I actually think the court made a mistake, and I think Justice Thomas actually had it correct in his dissent. Look, there's no question that state legislatures don't have a completely open hand when they're doing redistricting. Congress can overrule what they do. They're also subject to federal laws like the Voting Rights Act. But the exact situation in this case was that the North Carolina State Supreme Court overruled and threw out the redistricting plan when they had no legal authority to do it. They claimed that partisan gerrymandering violated the state constitution. There's nothing in the state constitution that says anything or puts any restrictions on partisan gerrymandering. That was really the problem. They acted, the state court, without any legal authority to do so.
So this is not the first case for the High Court this term dealing with voting rights.
Right.
The Supreme Court ruled in favor of black Alabama voters a few weeks ago in the Defense of Voting Rights Act, and just yesterday dismissing Louisiana's appeal of a ruling that found racial gerrymandering. Were you surprised by those decisions, Hans?
Yeah, in particular because in the Alabama case, again, the Supreme Court ignored its prior precedents. The Alabama case was one in which the challengers said that because the black population of the state is about a quarter of the state, they were entitled to 2 of the 7 congressional districts, and unfortunately, the Supreme Court agreed with that. The problem is the Voting Rights Act specifically prohibits proportional representation, and the court has said in the past that it's not going to approve redistricting plans in which the major factor used to draw up the boundary lines was race. They just kind of ignored their prior holdings and ruled in favor of the challengers and against Alabama. I think it was an error.
Now, there's also another redistricting case from Ohio that's pending. Do you think the justices will have any more to say about this issue before the election in 2024?
Yeah, I think they will. I hope that they finally start getting some of these redistricting cases right, and that means actually following their prior precedents is something that I don't think they've properly done.
Well, all right, Hans von Spakovsky with the Heritage Foundation, thank you so much.